Most people lose in family court before they even walk into the courtroom, not because they're lying, not because they don't love their child, but because they completely misunderstand the job of the family court. They think they're there to prove that the ex is a terrible person. They're not. They think the judge is there to hand out justice for everything that's happened over the last 10 years. They're not. Family court is not interested in deciding who was the better husband, wife, boyfriend, or girlfriend. It's not a relationship counselling session, and it certainly is not revenge with the judge sitting in the middle. The family court has one primary job: making welfare decisions for the children. Once you understand that, everything changes. Let's break it down for you. The best philosophy you can adopt as a litigant in person is this. If anyone tells you otherwise, they're wrong. Be child-focused. Be evidence-led. Stay calm. Be procedurally disciplined. Simple, right? But incredibly powerful. Very powerful. The legal framework reflects exactly that approach. Under the Family Procedure Rules 2010, Rule 1.1, the court's overriding objective is to deal with cases justly. That means fairness, proportionality, ensuring everyone can participate properly, and always keeping welfare issues at the forefront. Rule 1.3 makes it very clear that both parties have a duty to help the court achieve that objective. Rule 1.4 requires the court to actively manage the case, and Part 3A, together with Practice Direction 3AA, requires the court to identify vulnerability early and make directions that allow vulnerable people to participate fairly. In other words, the system isn't designed to reward the loudest person. It's designed to help the judge make the safest decision for the child. So what's the mindset that actually works? Number 1, welfare first, ego last. Before you write an email, before you even file a statement, before you stand up in court, ask yourself one question. How does this help the child? Not how do I destroy the ex? No. Every sentence should move the judge one step closer to understanding what's best for your child. 2, evidence over emotion. Your emotions are real. Nobody's saying they're not. Emotion isn't evidence. Judges work with facts, dates, documents, messages, school reports, medical records, chronologies, independent evidence. If you're saying something happened, ask yourself, can I prove it? Because the strongest cases aren't the angriest. They're the ones built on reliable evidence. Less is more. One well-evidenced point is worth far more than 20 pages of complaints. Judges read thousands of pages every year. The people who stand out are usually the ones who are clear, focused, and consistent, not the people trying to squeeze every argument from the last 15 years into one witness statement. Number 4, understand what the judge is actually trying to do. Family judges are generally managing risk, protecting welfare, and making practical arrangements that children can actually live with. They're rarely interested in deciding who's morally right, unless it directly affects the child's welfare. That's a huge mindset shift. Stop trying to win every argument. Start helping the judge solve the child's problem. Number 5, be credible. Not theatrical, credible. One exaggerated allegation can damage 20 truthful ones. If something is weak, say it's weak. If you don't know, guess what? Say you don't know. If you make a mistake, own it. Credibility is built by honesty, not perfection. Number 6, work with the procedure, not against it. Meet deadlines. Cooperate where you reasonably can. Prepare your documents properly. Agree what you can agree. The family procedure rules reward organized cooperative case management. If your paperwork is chaotic, the court may start wondering whether your case is too. Number 7, never see vulnerability as weakness. The law doesn't. If you or someone involved in proceedings is vulnerable, Part 3A and Practice Direction 3AA require the court to consider participation directions so everyone can take part fairly. That's not special treatment. That's ensuring justice. Now here's the practical reality. Judges generally respond well to people who stay calm under pressure. Answer the questions they actually asked. If you're speaking for more than 5 seconds, you're saying too much. Use dates, documents. You avoid interrupting, acknowledge weaknesses, and make realistic proposals centered on the child. On the other hand, long speeches, vendettas, unsupported allegations, trying to relive every moment of that relationship, or telling the judge what they must decide rarely helps your case. Rarely. So here's the philosophy I teach every single parent. Act like a careful case presenter for your child's welfare, not like a prosecutor trying to punish your ex. Every document you prepare should pass 5 simple questions. Is it relevant to the child's welfare? If not, cut it out. Can I prove it with evidence? If not, reframe it or leave it out. Is it concise enough for the judge to absorb quickly? If not, tighten it. Does it improve my credibility? If yes, keep it. Does it help the court make a practical order? If yes, keep it. It's probably worth saving. That's how experienced litigants think. They don't try to prove everything. They try and prove the important things well. They stay reasonable. They narrow the issues. They make the judge's job easier. Ironically, that's often more persuasive than trying to sound like a barrister, because judges aren't looking for best performance. They're looking for the most reliable person to help them make the safest decision for a child. If you're representing yourself in the family court and want practical guidance, not legal jargon, not false promises, but proven strategies that help you present your case clearly and effectively, book a one-to-one strategy call with me. We'll identify the issues that actually matter, strengthen your evidence, and make sure you're walking into court with a plan, not just hope. If you're not quite ready for that, subscribe to the channel. Every week I break down family court procedure, explain what judges really are looking for, and help litigants in person avoid mistakes that cost parents precious time with their children. Because the better you understand the system, the better you can navigate it, and the better chance you have of helping the court make the right decision for your children.